To the Office of Tax Appeals. My name is Kenny Gast. I'm the lead administrative law judge on this case. Joining me on today's panel, we have Judges Linda Chang and Win Dang.
Good morning.
Before we go on the record, I just want to cover a few housekeeping items. I'll try to be brief. First things first, is everyone here today who's supposed to be here?
No, sir.
Are you're missing someone?
Yes, Mr. Hurst.
Okay.
I may have explained that he's suffering from cancer and it's slight relapse in his condition, so he couldn't come in.
Okay, but you're okay proceeding with the hearing?
Yes.
Okay. And for the FTB?
Yes, we're fine proceeding.
Okay, thank you. Just to reiterate what I mentioned on the pre-hearing conference, OTA is an independent agency. We are not a tax court, and this is an informal process. Note that all three judges on the panel are co-equal decision makers and may ask questions of either party at any time today. We have a stenographer here today, Ms. Alonzo. She'll be transcribing everything you're saying when we go on the record, so please speak loudly and clearly. Ms. Hurst, I believe you'll be testifying today, is that correct?
Yes.
Okay, so I'm going to swear you in when you testify. So you'll stand up and raise your right hand, and then you can stay seated when you testify. All right, going over exhibits. The taxpayer submitted exhibits 1 through 10, is that correct?
That's correct.
Okay, and there were no objections filed by FTB?
That is correct.
Okay, thank you. And FTB submitted exhibits A through J, and Mr. Sony, there were no objections filed to those exhibits, correct?
That's correct.
Okay, and I was informed by Ms. Vaughn that Mr. Sony, you had submitted another exhibit, but it looks like you already submitted this before, correct?
That's correct. I just brought it with me.
Okay, and that, I believe that's exhibit 3.
Right.
Okay, all right, thank you. All right, and before we go on the record here, just to reiterate the times, I will speak for about a few minutes with introductions, and then I'll turn it over to you, Mr. Sony, for 30 minutes. You don't have to use all that time if you don't need to. Please focus on the arguments as well as the testimony. I don't know if Mrs. Hurst will be doing a question and answer type of testimony, or she'll just be talking through narrative.
Mostly talking through.
Okay, that's fine. Okay, thank you. And then I will ask FTB if they have any questions of the witness. The panel may have questions, and then I'll turn it over to FTB for 10 minutes, and then back to you, Mr. Sony, for 5 minutes. Does that sound good? Any questions before we start? No? Mr. Sony?
No, sir.
Okay. All right, panel, you ready? Okay. Okay, we are on the record. This is the appeal of Paul A. Hurst Sr. and Joyce A. Hurst. OTA case number 19034399. It is Wednesday, January 22nd, 2020. The time is approximately 10:04 a.m. We are in Cerritos, California. My name is Kenny Gass. I'm the lead administrative law judge on today's case. And joining me on the panel, we have Judges Linda Chang and Win Dang. We ask the parties to please state your names and titles for the record, starting with the taxpayer, and Mr. Sony.
My name is Jay Sony, and I'm an enrolled agent, representative for Paul and Joyce Hurst.
Okay. And do you want to say your name?
Joyce A. Hurst, and I'm the taxpayer.
Okay, thank you.
Brad Catino for the Franchise Tax Board. The spelling of my last name is C-O-U-T-I-N-H-O.
Marguerite Meunier for Franchise Tax Board, M-O-S-N-I-E-R.
Okay, thank you. We have 3 issues for today's case. First is whether for the 2008-2009 tax years, appellants have shown error in FTB's proposed assessments, whether for the 2008 tax year, appellants are liable for the late filing penalty, and third issue is whether for the 2008-2009 tax years, appellants are liable for the accuracy-related penalty. Both parties submitted exhibits for this case. Taxpayers submitted exhibits 1 through 10, and FTB has no objections. Is that correct?
That is correct.
Thank you. Therefore, all of taxpayers' exhibits will be admitted into the record as evidence. NFDB has submitted exhibits A through J, and taxpayer has no objections to them. Is that correct, Mr. Stone? Thank you. Therefore, all of FTB's exhibits will be admitted to the record as evidence. However, note that Exhibit J is argument, not evidence, the law summary. I'll just note that. Okay, why don't we go ahead and start with the taxpayer's presentation for 30 minutes. Before you begin, I'd like to swear in Mrs. Hurst. So if you could please stand, raise your right hand. Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Whenever you're ready, Mr. Sony, you may begin.
You know, please forgive me because this is the first time in front of a judge. I've been in front of agents, but it's just been one-on-one, so this is something new to me. This whole case is based on the fact that the IRS increased the income for the taxpayers for 2008 and 2009. That increase, I guess maybe it was done in 2015, but the FTB was informed by IRS in 2016. But like Exhibit 3 shows that in 2015, the taxpayers submitted an offer in compromise to the IRS. And subsequently, that offer was accepted, and was accepted November 30th, 2016. So you know, it was like about 6 years since the tax years of like 2008 to 2016. That's 8 years, and 2009 is almost 7 years. The taxpayers do not have records of all that the IRS said that that they increased, and the reason they don't have those records is firstly, the tax returns were prepared by Mr. Hurst, and as has been stated, Mr. Hurst is now suffering from cancer, and because of that, he's not able to be here. But not only that, he does not, or he can't even remember where he put the paperwork, like mortgage statements, invoices, bills, or whatever. So FTB, obviously needed those records so that they could accept the numbers that the taxpayer had. But we don't have them. And a lot of the expenses that the IRS did not accept, they, like 100% left them out. But when you're a business, there's always some kind of expense, and we would have thought that at least some expense should be given. Now, we did not fight the IRS contention on the income and expenses, and that was because at that time Mr. Hurst just got the news that he had stage 4 cancer. Rather than go through a protracted thing to prove all the expenses, he entered into an offer in compromise with the IRS, and the IRS accepted it. It seems like unfair for the FTB to now say that the taxpayers are due all this money, plus all the penalties and interest. Maybe we can concede, okay, because we can't show you the proof of the expenses, maybe you can increase the taxes. But to almost double it by the penalties and the interest seems to be a little unfair, because now it's almost 20 years, and people don't keep these documents as they should. And also, after they filed their taxes in 2008 and 2009, which they filed in 2010, they didn't think anything about it. Now it comes up in 2016 that the IRS said it's incorrect. By that time, a lot of the paperwork was lost. And then to try to talk with Mr. Hurst about the paperwork was really a difficult time. Even now, Mrs. Hurst is going through a difficult time because she has to look after Mr. Hurst. And he needs medication, he needs attention, his mind, is like in and out. So sometimes when she's talking to him, he understands her, and sometimes, he doesn't understand it. So for the taxpayers to pay a little over $60,000, I think it's a little harsh, because it took both the IRS and the FTB such a long time to correct the tax returns that were filed. The FTB got the new numbers from the IRS in 2016. They sent a notice of proposal in 2018, 2 years later. And during that time, the penalties and the interest accrued. And so there's an extra 2 years of penalties and interest. And like I say, the taxpayers are not so much concerned about the tax that they owe, because they can't prove that they don't owe the taxes. But what's really tough on them are the penalties and the interest that they've accrued in all this time. So with that, Mrs. Hurst has a statement and something to present to the court, and it has to do with the, I think it was Exhibit 10, where we sent the bank statements that showed that they paid interest. The loan was in the son's name, and I'll allow Mrs. Hurst to tell the court why they paid it instead of the son. And they feel that since they paid the interest and they own the house, that that interest should be accepted as part of the expense. So with that, put it over to Ms. Hurst, and she can talk about that.
Yeah, we were initially denied mortgage interest and property taxes.
I'm sorry, Ms. Hurst, if I may just interrupt you briefly, and I apologize for doing this. I'd like to clear up an issue before you proceed with your testimony.
Okay.
It's my understanding, based on a review of this file, that the FTB has not disallowed any of your expenses that you provided here in Exhibit 8, 9, and 10 relating to the Wisteria property. It's my understanding that those expenses were allowed. The deduction for them against ordinary income, however, was not allowed. That those expenses actually were not.
From reviewing the record, and appellant's tax returns, it's hard to determine what was allowed and what was disallowed. FTB followed the IRS's determination in proposing additional tax. And it appears there's multiple properties on Schedule E that were claimed. Unsure if some of those were disallowed and some of them were allowed. And then for Schedule C, it appears that there was a substantial amount of mortgage interest deduction that was claimed. And for that, it appears some was allowed and some was not. But it was unclear to FTB which ones for which properties were allowed and disallowed.
Okay, I'm looking at Schedule E, column C of
For the 2008.
Correct, for the 2000, let's say for the 2008, for example.
Yes, it appears there's 3 properties that were claimed in that. There was the Wisteria Lane Avenue, the Moreno Valley, and then the first Moreno Valley. I don't know if there was a breakdown from the IRS which ones were allowed and disallowed.
Mr. Sunny, those are the expenses for which you submitted Exhibit 8, 9, and 10 pertaining to.
The IRS did disallow, according to Mr. Hurst, the mortgage interest of $23,925, and the FTB is going according to what the IRS has determined. So that means it was not accepted.
Was the interest itself disallowed on Schedule E, or was the fact that you had deducted those amounts against ordinary income, the deduction itself was disallowed, but they allowed you a net operating loss carryover for those mortgage interest and the other related rental expenses?
See, no, on the ordinary income, Mr. and Mrs. Hurst were and are professional real estate people. And I thought that their expenses, like for an ordinary person like me, is up to 25%, where we can deduct the 25%.
You mean 25,000?
25,000, sorry, yes. And they deducted 77,000, but they are professionals, and I thought that's the IRS code that they can deduct that, but they didn't allow that.
So if I'm understanding you correctly, the IRS disallowed the deduction, but they didn't question you as to the whether or not the taxpayers had incurred those expenses and whether or not you were entitled to a net operating loss carryover for those.
Okay, so that I don't know, and the reason I don't know is, like I said, when the IRS corrected the numbers, or said they corrected the numbers, we did not fight it. As a matter of fact, I wasn't the one that prepared the OIC. There was someone else in our office that did that because he was in charge. But since he left, I took over the case. But so they decided not to fight anything. They said the best thing to do is to do an offer in compromise, an ETA offer.
Okay.
And so we didn't fight anything. And that is where the problem is between the FTB, I guess, and the IRS. Because on the one hand, they accept the IRS's numbers, then on the other hand, they don't, because the IRS shows on the account transcripts, Mr. and Mrs. Hurst owe no money. And that's when I called the FTB with the notice, that proposed assessment. When I called them, the agent told me that what I would have to do is submit the OIC, submit that paperwork, and say that the IRS accepted the OIC. And then when I sent it, that was rejected. And then, we had to
I understand. Yeah. My concern is that you may be expending effort on an issue that's not at issue here. My understanding is that, and I'm going to ask the franchise tax board, is that California does not conform to the real estate professional provisions of the IRC. That these passive activity expenses would not be deductible in any case, regardless.
I believe that's correct, but
Okay, so it sounds as if even if you were to substantiate, even if we all agree here, that it would not reduce Ms. Hurst your tax liability in this case.
If I may interject there, I think, so exhibits 8 through 10 relate to the Wisteria Moreno Valley property.
Correct.
That was claimed as rental property income and expenses on the filed Schedule E returns for 2008, 2009.
Correct. And those expenses were denied because the loan is not in our name.
Well, I think that's where Judge Dang was asking questions around, because when you look at just focusing on what FTB did, on the MPAs for 2008, just focusing on 2008 MPA, there is a disallowed deduction of $77,717. But that's just the excess deduction from Schedule E, which means that the FTB has allowed all of the claimed expenses on Schedule E. They're just disallowing an excess passive loss from offsetting ordinary income. That's what I think Judge Dang was getting at.
That might be a bit difficult for you to understand, but I think the gist of what what this comes down to is that even accepting everything that you provided today, it would not change your tax liability. That's the ultimate result. Would you like a few minutes to discuss this with your representative? I might be able to better explain this to you.
Okay, so it seems like Mrs. Hurst now kind of gets.
Okay. Would you like to proceed with the additional time you have? 10 more minutes for your opening presentation?
No, I'm done. Unless Mr. Hurst wants to say something.
Okay.
As Mrs. Sony explained, my husband actually did the taxes. I know we're both liable, but he did everything. He did taxes, he paid bills, he did everything. So he was diagnosed in actually 2013. And since then, it's been a strain. He was diagnosed with stage 4. He has cancer of the bone. So it's been a lot of strain on us, so much so that he can't help me dig out what he did in 2008 and 2009. So what I am asking is if we could resolve this as soon as possible so that we can probably get to an offer of compromise or something, because
I'm sorry, do you need a few minutes?
no, I just want to get it resolved as soon as possible so that I can focus on our family and taking care of his needs.
Do you have anything else, Mr. Sony?
No, sir.
Okay, thank you. Mr. Catino, do you have any questions for the witness?
We do not.
Okay. Panel members, any questions?
Have no questions.
No questions.
Okay. I have no questions. Mr. Catino, you will have 10 minutes.
Thank you. In light of the testimony today, FTB will keep it short and rest on most of its opening brief. However, we state that while appellant's circumstances is certainly a sympathetic situation and appellant's health is obviously the circumstances that dictates in this appeal. However, in regards to the federal assessment and the penalties imposed, appellants haven't established any evidence to show why the federal assessment on a legal basis is incorrect, or any basis for the abatement of the penalties or interest in this matter. And we don't have discretion in regards to those penalties and interest. FTB would like to note that appellants provided an offer of compromise entered into with the IRS, but the offer in compromise explains that appellants agreed to the deficiency due to the exceptional circumstances of appellant's husband's health. If sustained in this action, FTV can provide appellants information at the conclusion of this hearing or at the conclusion of the OTA's decision, information regarding its offer in compromise program, and walk them through that. And the offer in compromise program looks into the ability to pay, and as well as the future ability to make income. In this case, if sustained, FTV would be willing to discuss further its offer in compromise program with appellants. Thank you. Do you have any questions?
Thank you. Any questions from the panel for FTV?
No questions.
No questions.
Okay. Mr. Sony, you will have 5 minutes if you'd like on rebuttal.
Okay, so we are just thrilled that the FTV is willing to give the taxpayers an offer in compromise submission, and that's what the taxpayer would like to do. Obviously, you know that she's been going through a lot of stuff. She said that Mr. Hurst was diagnosed in 2013, so it's about 7 years now. And she wants to put it, you know, but also we want to do a payment or compromise, you know, according to what her finances will allow, because Mr. Hurst cannot work. Mrs. Hurst is.
We understand that. This body is to determine if the tax is properly imposed. That's something you would have to discuss with FTB, but I appreciate your comments on that.
All right. Thank you, sir. That's it.
Okay, thank you.
We will talk to FTB after the hearing.
Okay, thank you. One question we do have, Mr. Sony and Mrs. Hurst, are you prepared here to concede the entire liability, tax, penalties, and interest for the 2008-2009 tax years?
The penalties and the interest is something that we are not happy with. And the reason is that it took so long for it to be amended or corrected. And so in the meantime, the taxpayers are accruing the penalty and the interest. And it kind of seems a little unfair to the taxpayers that's going on. So if some of the penalties could be abated, the taxpayers are willing to go through the whole thing.
And Mr. Sunny, I think we are willing to consider the penalty abatement, as you mentioned, but as Franchise Tax Board has also mentioned, we don't have the discretion to do that based solely on any type of equitable reasons that you may have provided. Do you have perhaps a legal argument?
No.
Okay. Thank you.
Okay, I think that is it. Did you have something else, Mr.? Okay. All right, so this concludes the hearing. I want to thank both parties for coming here today. The judges will meet and decide the case based on the documents and testimonies presented and admitted as evidence, and we will aim to send both parties our written decision no later than 100 days from today. And the case is now submitted. The record is closed. The hearing is adjourned. Thank you.
Thank you.
We're going to take a 5-minute break. Thanks.
You're ready to hear the appeal of Frank Bowman, case ID 18103940. It is 10:35 p.m.
Good morning. Before we go on the record in this matter, I wanted to go over a few preliminary things, mostly what we talked about at the pre-hearing conference. The Office of Tax Appeals, primarily for your knowledge and benefit Mr. Bowman. We are an independent agency. We only have seen what has been submitted to us in the briefing process. We're not affiliated with the Franchise Tax Board. This morning I have with me Judges Richard Tay and Win Dang.
Good morning.
And I'm Teresa Stanley. We will all be hearing your case and deciding it together. We make co-equal decisions amongst us. And for the, not for the record, but just for the taxpayer, Mr. Bowman. And for respondent,
Mira Patel.
Mira Patel. And the issue is whether the appellant, Mr. Bowman, has shown that the Franchise Tax Board erred in granting innocent spouse relief to Angela Bowman, who is his former spouse, correct?
Still current
Current spouse.
in divorce process since 2007. In divorce process since 2017.
At the pre-hearing conference, we discussed exhibits 1 through 8 for Mr. Bowman, and then he did submit additional documents number 9 and 10, exhibits 9 and 10. And Ms. Patel, do you have any new objections to any of those?
No objections.
Okay, so when we go on the record, those will be admitted into evidence. Mr. Bowman, I did want to make a note that Exhibit 9 appears to be a confidential document, and I'm asking if you would like the Office of Tax Appeals to seal that record upon completion of this matter.
Yes, please.
Our Rules for Tax Appeals, number 30312 says that a party may request sealing of a confidential document, and we will do that, so that in the event that there is any public records request, that document will not be released. And then for Franchise Tax Board, we discussed exhibits A through I, and Mr. Bowman, you still have no objection to any of those documents being entered as evidence?
No.
Okay, so those will be admitted when we go back on the record. And I understand today that Mr. Bowman, you will be your only witness,
Correct.
and Ms. Patel, you have no witnesses to present.
That's correct.
Okay. Okay, then we are going to go ahead and go on the record, and when you speak, I'll ask that you speak slowly and clearly so that our stenographer can catch everything. It's also being recorded, but we don't like to have to go back and compare the written transcript to the auditory tape. So this is the appeal of Frank Bowman, case number 18103940, January 22nd, 2020, and the time is 10:39 a.m. and we are in Cerritos, California. Once again, I'm Judge Teresa Stanley. I have Judge Richard Tay and Judge Win Dang. I'll conduct the hearing, but they will be equal participants, and they may have questions of either party here today. Mr. Bowman, for the record, can you please state your name?
Frank Bowman.
And Franchise Tax Board?
Mira Patel, that's Patel.
Okay, we have appellants exhibits 1 through 10 that will be admitted into evidence, and Franchise Tax Board's exhibits A through I will be admitted into evidence, all without objection. To restate the issue is whether Mr. Bowman, who is the appellant, has shown that the Franchise Tax Board erred in granting innocent spouse relief to Angela Bowman. Because there's only one witness here today, we're going to forego opening statements, and we will start with Mr. Bowman's case. Will you raise your right hand Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. I think that you may need to press the button to turn on the microphone. If it's-
Green light?
It's green, okay.
I guess I have to
Now I
put
can
those-
hear you.
I'm sorry.
Okay. All right, thank you. And you asked for 25 minutes to present your case, and so I'm just going to let you tell us what you want us to know, and you can use narrative form or whatever's comfortable for you.
Thank you. When I heard that this was being disputed or as innocent spouse, I took the time and I went and researched what are the criteria to meet innocent spouse, and I found 4 items, and I'd like to read those items and then I'll address those items. The first item was change in standard of living or levels of income as a result of the transaction in question, the sophistication, education, and level of experience of the spouse seeking relief, the involvement of an alleged innocent spouse in the business or financial affairs of the family, and the degree to which the other spouse has been evasive or deceitful about finances or the transaction. So this is in reference to the joint tax return on 2012. So that would be the actual year of 2011. And so what I'd like to do is just address each one of those quickly and concisely. On changes of living and standard, we were in the same house for over 6.5 years from that time of 2011 while my kids attended high school in La Costa Canyon, California. The sophistication in education and level of experience of my wife is second to none. This woman has an accounting degree from Loyola University, has passed the state bar in the state of Florida, worked for the Attorney General Janet Reno. She also passed the bar in the state of California, and she also is a financial planner, Series 7 license with a 65 and a principal's license. She also passed the insurance exam and was a property and casualty and life insurance agent. She worked for the Arizona State Supreme Court as an attorney for the Supreme Court of the state of Arizona. She has written laws on domestic violence, and she has anchored the NSHIP program for the state of Arizona, also managed over 25 employees for the state. So this is a woman who has quite a level of experience, knowledge, and understanding of many things. I am a high school graduate and I'm self-employed. Let me take you back to the, well, 1 second, please. Number 3 is the involvement or allegedly innocent spouse in business or financial affairs in the family. Up until 2007, she paid all the bills. She did everything until May 27th of 2007, when she went in for a routine surgery. 3 days later, bled out and became disabled, where her boys found her on the bathroom floor where they had to revive her. So that has led to a lot of struggles in our life. In that same year, 3 months later, my 2-year-old daughter was mauled by a dog and has facial scarring. Then we were evacuated for 2.5 weeks from the fires, and then my son had to go in for surgery. Since then, it has been quite a struggle. The bottom line is that in 2007, when the injury happened, to the question of return was 2011, was 5 years. In 2011, she was able to open and initiate getting a bank account where she made a deposit of $12,000. She was daily, had access to all her credit cards, had her own car. She had a MacBook Pro, she had an iPhone, 2 iPads, and the bottom line is she had access, she had means, and she had the ability to know what was going on. She also signed all our tax returns since we were married in 1994. She also was involved in our offer and compromise and actually spent time with our CPA who put together and started the offer and compromise. So she was well aware of the tax liability on the federal and the state. The reason why this is very difficult, it's simple, is that it seems that she is disabled for certain things and not disabled for other things. And that has been the biggest problem with our children and all the events that she has missed. Because someone chooses to stay in her room or not get out of bed or do certain things, doesn't mean that they're not aware of things. As you can see from all the pages that she wrote, it looks like it was a horrible 23 years. Just to set the record straight, an independent mediator in our divorce granted custody to myself for my daughter. All the allegations that she made in those statements that she wrote in here and she wrote to the courts, all were either not substantiated or found untrue. The bottom line is she had the ability and the knowledge of what was going on, and in 2011 there was no additional hiding or evasiveness. The problem with someone that has had major blood loss is their cognitive function. And with that comes days of no getting out of bed, no doing anything, leaving the house, but then there are good days. And in those good days, and we went through a cycle of every 60 to 90 days where we would go over all the banking information, all the passwords, and it was repeat every 60 to 90 days. And then I'd give her all the information. She would just forget about it or not use it. So these are some of the things that can, if you know the history of the whole picture, it's a different perspective. A lot of the things that she said and what I told the mediator was accurate, that it did happen, but the results are different. And that's based on her cognitive abilities and functions. So all I wanted you to do was to understand the timeline of when that tax liability was due, all the things she did in that same year. She had the ability and she could do all those things, and there was no innocence or deceptiveness on my part of the tax liability. Plus the simple fact that she did the offer and compromise, signed it, met with the CPA, and all these other additional things can go to prove that there was no deceptiveness, no change in anything, and she just knew what was going on. So, thank you.
Ms. Patel, do you have any questions?
No questions.
I just had one brief question. It was my understanding that the year at issue is 2012, is that correct?
Yes.
But you were just testifying as to events which occurred in the year 2011?
The tax year 2011, she actually opened a bank account, so that would show that I had no knowledge of the bank account until this divorce proceeding. So it showed that she had the ability to function, open a bank account, go online, and make a financial transaction. In the same year, she's claiming she had no knowledge or the ability, or I suppressed her from getting an actual, being financially independent.
Thank you.
Judge Tank?
No questions.
I had just one. You were testifying that she met with your CPA with
Correct.
you.
Jeffrey Klein.
Was that in respect only to the IRS debt?
Correct, to the IRS offer and compromise, which was still laid out all our tax liabilities from the Franchise Tax Board, and we discussed whether we could work with the Franchise Tax Board and do it, and he just said they were very difficult. It was easy to work with the federal government, so that's what we did.
So you did discuss the franchise tax
Yes, we
debt
did.
with the CPA?
Correct.
Okay. All right, do you have anything else that you wanted to add?
No.
Okay, then and we'll conclude with that presentation. And since the Franchise Tax Board has no witnesses, what we're gonna do is go straight to closing arguments. I wanted to make a note that I didn't on the record that pursuant to our rules for tax appeals, regulation section 30312, the OTA will seal appellant's exhibit 9. And now I'm going to give you time to kind of bring your evidence together for us, and you can argue how that evidence supports your claim that she's not entitled to relief.
Thank you. In closing, I'd like to say that she had the ability, the means, and the opportunity to engage in any financial transactions. In 2011, she actually did open up her own checking account, unbeknownst to me, but she did open up her own checking account. She had access to credit cards, she had access to the internet, she had many multiple devices. I can't control the fact that she chose to stay in the house and not leave the home due to her own disability. But the disability had nothing to do with her brain, it had other issues. She's still the same woman that passed the state bar in 2 states, worked for the Supreme Court, had much more knowledge than myself as a high school graduate. And that's all I need to say.
Ms. Patel?
Respondent properly granted innocent spouse relief to Ms. Bowman for the 2012 tax year, and appellant has not shown error in respondent's determination. Appellant and Ms. Bowman filed a married filing joint return for the 2012 tax year, reporting appellant's business income and Ms. Bowman's Social Security disability income. They self-assessed taxes on only appellant's business income, resulting in a tax due of about $5,000. However, no payment was made with their return. After respondent began collection efforts on their self-assessed tax liability, Ms. Bowman timely requested innocent spouse relief. Based on the fact that their 2012 liability was self-assessed, relief was available to Ms. Bowman under Revenue and Taxation Code section 18533F. Ms. Bowman met her burden to show that she satisfies the 7 threshold conditions as enumerated in respondent's opening brief to be considered for section F relief. She also established that she meets the 3 requirements for section 4.02 streamline relief, and additionally showed that she meets the section 4.03 balancing factors, establishing that she's entitled to innocent spouse relief. Appellant's only arguments on appeal are that Ms. Bowman participated in their financial affairs and the tax liability is attributable to her cancellation of debt income from her student loans, as argued in the appellant's opening brief. Both of these arguments do not establish that respondent erred in granting innocent spouse relief. First, with respect to the knowledge requirement. Appellant allegedly had Ms. Bowman declared unfit to manage finances in order to receive Ms. Bowman's Social Security income. Additionally, Ms. Bowman's request and statement from her father both indicate that Ms. Bowman had little involvement in their financial affairs and did not know of the underpayment for the 2012 tax year. Even the additional exhibits provided by appellant shows Ms. Bowman was not capable of managing finances and that appellant maintained control of their financial situation when they were living together. Second, with respect to Ms. Bowman's student loan forgiveness, Ms. Bowman neither had cancellation of debt income in 2012 nor reported cancellation of debt on their joint return in 2012. Appellant seems to refer to their 2011 tax return, which again, as stated, is not at issue on appeal. Based on the arguments made on appeal, appellant has not established that respondent erred in granting Ms. Bowman innocent spouse relief for the 2012 tax year. Therefore, on the facts and evidence in the record, respondent respectfully requests you sustain his position. Thank you.
Thank you. Mr. Bowman, you can have the final word and address what Ms. Patel has stated.
Oh, sure. On her first statement that there was, on the tax liability, that it was underreported, we reported it, we had the tax liability, but we've been in payments plans for almost 15 years at $650 a month. and I sent those records, you can see that all those payments, so there was no surprise that there was a tax liability, nor was it that they were coming after us for that money. We were already in actual collect, we were paying $650 a month forever. I mean, forever. Then she said that I declared her unfit. No, I had nothing to do with it. The disability told me that that's what the process was. We've never been through the state disability or the government disability. They told me to fill out the forms. I followed the directions. She got disability on the first time. I didn't declare her anything. I didn't have the ability to declare her in any way. I just followed what they told me to do. Never had that happen before, never known what to do. They just told me this is what I do, I did it, and that was it. I didn't declare her anything. Maybe her medical doctor did, but I didn't do it. There was, and then she said there was no underpayment. There was never, we knew what the taxes were. It wasn't an underpayment of anything of the tax liability. The tax return was what it was. We had a liability and we couldn't pay it. So we've been paying on the $650 a month forever. And she referenced that I was talking about the tax year 2011. I never made reference to tax year 2011. I said it was 2012, but the actual year of real world was 2011. And those are when the items happened. So in 2011, if you have the filing in 2012, it indicates what happened in the year 2011. So what I'm trying to say is that a lot of that stuff that she said doesn't have any merit to what has actually happened in the ability for her to know what was going on. That's all. Thank you.
Okay, I don't usually like to do this after people have concluded, but I did notice, Ms. Patel, that you said that he had her declared unfit, but I didn't see anything in the record that indicated that. Do you have an exhibit you could point to that would show us that?
That fact is simply from Ms. Bowman's innocent spouse request file, Exhibit I.
Okay, so it should be included in Exhibit I.
Yes.
Okay. Do you have any other follow-up questions?
No questions. For Franchise Tax Board, in terms of the qualifications for the streamlined relief, would you mind discussing economic hardship?
So for the streamlined relief, there are 3 requirements. So Ms. Bowman established that she had the 7 threshold requirements, which then would require her to show that she has streamlined relief. The second of the streamlined relief is the requesting spouse will suffer an economic hardship if the relief is not granted as set forth in 4.032B. Economic hardship exists if partially or wholly satisfying the tax liability would cause the requesting spouse to be unable to pay reasonable basic living expenses. As stated or as explained in respondent's opening brief, the only income that we have record of for Ms. Bowman is that Social Security disability income that she's currently receiving, and that was also included in her innocent spouse file. We're not sure what kind of expenses her parents are paying for her currently because they are living separately right now. But the total amount, I believe, as stated in respondent's opening brief, was about $1,000 a month, which in comparison to the federal standards for basic living expenses did fall within a lower level of income. And so this factor was met simply because her monthly income and annual income, quite frankly, was not sufficient enough in comparison to the tax liability.
So the relevant year that you would look at to determine economic hardship, would that be this year or would it be?
That would be the current year right now because the tax liability would be due as of right now. It was due in 2012, but currently requesting innocent spouse relief, would it cause a financial hardship on her? Currently, our determination was yes, it would.
And how does spousal support work into that calculation?
Spousal support is considered as income received. However, based on Ms. Bowman's innocent spouse request, She had indicated that she was not receiving regular spousal support payments.
Okay, and if she were receiving regular spousal reports as dictated by the court order, would that change that element of the streamlined relief?
I think ultimately you would go into considering how much her annual income or monthly income was, but she also is required to pay for child support in addition to that, so that's a subtraction from her her income that would be received. So, like I said, this income wasn't considered because she did not receive it, but I think there are other things that should be considered if she did actually receive it.
Okay, yeah, may I ask?
Can I
Sure.
respond?
Yeah, I'm gonna give you a chance to, I always let the appellant have the last word, so I'm gonna let you respond to anything that she said, but I think Judge Tay has more questions and maybe some for you.
Oh, mine was just to ask if it's okay if the appellant responds.
Oh, okay, we're all on
Thank
the
you.
same page then.
Great, I'd
Yes.
love to respond to the hardship on her income and that income. I was ordered to pay $26.54 a month, which I have been for the last 2 years or so. And then she was to grant to pay me $36 a month due to the fact that I had our daughter. But actually last January, our daughter expressed interest in being with her mom, and my wife has been getting a lot better and being able to almost live on her own at this point. And she actually got an apartment or a house and is now living on her own. And just so you know, for the last 12 months, I've been paying her $3,664 a month without a court order, based on, obviously the calculations my attorney before, if I were to pay child support. So it's not that I'm not going to pay this debt of the $5,000 in the 2012 tax year. This is a principal thing. I'm paying it. I'm gonna pay it. Nobody else is gonna pay it. I'm not asking my wife to pay it or to be responsible for the debt to pay it. It's just when I get to the final divorce proceedings, it's just on my balance sheet as something that she owes. I'm paying the debt. I'm still paying it every month, and I'm gonna pay it off. This is I'm down to about $4,000 total. But the bottom line is that she does have income. She doesn't report that income. I can't control that, what she wrote and what she does do. But you can see the court order, or I can provide you what I have been paying and what I don't have a court order for and have been paying, which is $36.64 a month for the last year without a court order. Thank you.
Is that it? You're okay? All right, well, thank you both for presenting. We'll take this under submission and make a decision, send out a written decision in 100 days or less. And we are going to recess for 10 minutes before we go to the next case.
Thank you.
Thank you.
Thank you.
Good morning, we will now resume. We are ready to hear the appeal of Judges Charles and Julie O'Rear, case ID 180-11101. It is 11:15 p.m.
Thank you, Ms. Vaughn. We have a few matters before we go on the record in this case. First of all, I wanted to let the appellant know that the Office of Tax Appeals is independent. We are not a counterpart or co-part of Franchise Tax Board in any manner. The only evidence that we have to consider a decision in your case is the evidence that's been presented to us already, or that you and your witnesses will testify to. So this morning, I'll be leading this process, but my co-panelists, Judge Richard Tate and Judge Scott Ewing, will be making a co-equal decision with me in your case. And for the appellant here today, can you state your names for the record? Well, we're not on the record yet, but just state your name so we know that you're here.
Sure. Good morning. My name is Lane Lopez. I'm the attorney for the taxpayer, Julie Ford, formerly Julie O'Rear, who's to my right.
Okay, and for Franchise Tax Board?
Brandon Moore. Brian Catino.
Okay. Sorry. Okay, we have two issues today. I'm not sure how much evidence there will be to point to one or the other, but the first issue that was raised on appeal is whether appellants Julie Ford and Douglas O'Rear have established that they had a basis in securities that were sold in 2007 and 2008 that is greater than the basis that was allowed by the Franchise Tax Board. And issue number two is whether Julie Ford is entitled to innocent spouse relief for 2007 and 2008, and if so, is she entitled to partial relief or full relief? Do you still agree that those are the issues, Mr. Lopez?
We do.
And Mr. Knoll?
Yeah. Yes, we do. Yes, we do, and we'd just like to point out Mr. Knoll will be addressing the substantiation issue, and I will be addressing the innocent spouse issue.
Okay, teamwork. Alrighty, we had discussed at pre-hearing conference that there was no objection to appellants exhibits 1 through 3 and the respondents exhibits A through R. Is that still true, Mr. Lopez? No objections?
No objections, Your Honor, although I would note that the documents submitted by the appellant were submitted by Mr. O'Rear and not by Ms. Ford.
Correct. And she joined, Ms. Ford joined in the appeal.
That's correct.
Okay. And is there any Franchise Tax Board objection at this point to any of these exhibits?
No. No objection.
Okay. So when we go on the record, we'll admit those into evidence. And just to address the issue, Mr. Lopez, you have Ms. Ford here to testify today, and you had indicated that Mr. Gelsich, you want his testimony, but he's unable to be here today.
That's correct. We've attempted to reduce his testimony down to a one-page affidavit. He has that affidavit, and he is in the process of having his compliance department at work approve it. He had to run it up the flagpole, but we expect him to sign it, and we would like to make it part of the record in the next 30 days.
Okay, and when we go on the record, I'll note at this point too that when the appellant requested telephonic testimony, that Franchise Tax Board objected, and under the current rules for tax appeals, we cannot grant that over the objection of any party. So what we talked about as an alternative would be to use the witness declaration route and allow him to submit a witness declaration, but under our rules for tax appeals, 30420 subsection C, we would need to give the Franchise Tax Board an additional 30 days to consider it and to prepare any questions they might have, and then give the witness an additional 30 days to respond to any questions that are propounded. So when we are on the record, I will set timelines for that. Unless you have, Franchise Tax Board, are you objecting to that route? No
objections to that process.
Okay. Alrighty then, we will go on the record, and please, when we're on the record, when you're testifying, primarily Ms. Ford, just speak slowly and clearly so that our court reporter can catch everything that is said, and it's also being recorded. We'll have audio and video recording as well. Okay, on the record, in the appeal of Douglas Charles O'Rear and Julie O'Rear, now Julie Ford, case number 18011-101. The day is January 22nd, 2020. The time is 11:21 a.m. and we are in Cerritos, California. I am Judge Teresa Stanley. I have to my left Judge Richard Tay and my right Judge Scott Ewing. And I'll ask for identification on the record. Mr. Lopez.
Good morning, Lane Lopez for the taxpayer Julie Ford, formerly Julie O'Rear.
Taxpayer Julie Ford.
Brandon Gold, Franchise Tax Board.
Brian Catino, Franchise Tax Board.
Thank you. We will admit appellants exhibits 1 through 3 into the record, and we will admit Franchise Tax Board's exhibits A through R into the record as well. That is without objection by either party. The two issues that are before us today are whether the appellants have established that they had a basis in securities that they sold in 2007 and 2008 that is greater than the basis that was allowed by the Franchise Tax Board. And the second issue is whether Julie Ford is entitled to innocent spouse relief for 2007 and 2008, and if so, is she entitled to partial or full relief? We're going to start with opening statements, and Mr. Lopez, that means you can explain to us what you believe the evidence is going to show us today.
Thank you. Good morning to the Office of Tax Appeals and to the judges on the panel and to FTB Counsel. On behalf of the taxpayer, we appreciate your time and consideration of this matter. This case involves the marriage of my client, Julie Ford, formerly Julie O'Rear, and her former spouse, Douglas O'Rear. At the time in question, the 2007 and 2008 tax years, Julie was a committed homemaker who homeschooled her 3 children. As you will hear today, Doug was a secretive, evasive, and dishonest partner who thought he was smarter than everyone else, and in particular his wife, Julie. Doug was so smart, in fact, that he did not believe he needed to share any of his business or financial information with his wife. Doug was also paranoid and did not trust anyone, especially with his business matters. He didn't need to tell Julie the specifics of what he did for a living or when he was leaving out of town, because that's typically how Doug treated Julie. In fact, being so smart, Doug thought Julie could not possibly understand or comprehend the nature of his business. Doug would feed her generic information, such as he was involved in big business deals, and you wouldn't understand what I do for a living. You will also hear today of how Mr. O'Rear intimidated, controlled, and demeaned his wife, concealed his finances and business dealings from her, and ran a business that he actively hid from his family. Doug would regularly leave town without notice and would be gone for long stretches of time. He refused to tell Julie in advance where he was going or the purpose of his trips, other than they were for business. When it came time to prepare taxes, Doug alone would take his information and documentation to H&R Block or a similar tax preparer. Doug would not give Julie an opportunity to review the tax returns before they were filed, going so far as to have her sign them in the parking lot of H&R Block. In the course of paying the household bills, one of the few areas that Douglas would actually permit Julie's participation, Julie would write checks to IRS and FTB for taxes. Julie was reasonable in her belief that she was reporting and paying her taxes in proper fashion. The fact is that she was not allowed to know about Doug's business dealings, which he refused to discuss with her, despite her various inquiries over the years. Taxpayer also intends to submit a declaration from Attic Gelsage, Doug's former stockbroker, who later became Julie's financial advisor following their divorce. And he will affirm that he had no contact or interactions with Julie prior to the divorce, and that she was in no way involved with Doug's business dealings or decisions revolving around the family business. Eventually, the secrecy, deceit, and evasiveness reached a tipping point. The marriage came to an end some 22 years after it started. To this day, Julie remains in the dark about Doug's business dealings during their marriage. To this day, Doug has little to no contact with his children. He has paid no child support and a negligible amount of spousal support, despite a divorce judgment almost 10 years ago. In his divorce agreement, he conceded in writing that he was responsible for the taxes in 2007 and 2008. And despite this, he is absconded, leaving Julie to raise the kids and clean up the mess that he created. The critical matter in this case revolves around the basis in stocks that Douglas sold in 2007 and 2008. The FTB has allowed the basis claimed by Doug due to a lack of documentation. The reality is that the only person with access to that information and documentation is Douglas. Douglas was responsible for tracking the numbers, tracking the business. He did not share any information with Julie, and he is the only one who knows how these numbers were determined and generated. Almost all of the stocks acquired by Doug were closely held and not sold on the open market at the time they were acquired. Even in the few cases where publicly traded, even in the few cases where the stocks were publicly traded when Doug acquired them, we don't know how many shares were bought and sold in order to substantiate the basis. So even with public records and information that's the only thing available to Ms. Ford, she's still unable to determine how and why Doug used the numbers that he did. This has put her at a significant disadvantage. Douglas's non-participation has adversely affected Julie and her ability to gather information and documentation in support of her case, and to compel Douglas's testimony in this matter. To the extent that Douglas is not a participant in this hearing, we would object to any adverse adjudication against Ms. Ford, since she has not had a reasonable or adequate opportunity to obtain records and information in Douglas's possession that may be relevant to this matter. And furthermore, this very matter was deemed not ripe for settlement due to Douglas's absence from the proceedings. Therefore, Julie's efforts to negotiate a reasonable good faith settlement to resolve this matter short of a hearing has been frustrated again by Douglas's absence. Therefore, Julie objects to any adverse determination or adjudication prior to Douglas's involvement. Based on the testimony that we will present today and the evidence in the record, we believe that Julie meets the criteria for innocent spouse relief, and we would ask that the Office of Tax Appeals render a determination as such. Thank you.
Thank you. Franchise Tax Board, would you like to make an opening statement?
I believe we waived our opening statement during the pre-hearing conference, just to note that, as we stated earlier, Mr. Knoll will be addressing the substantiation issue, and I will be establishing why Mrs. Ford is only entitled to partial innocent spouse relief under 18533 F. Thank you.
Okay. Thank you, I do recall that. What I'm going to do is ask Ms. Ford to raise your right hand and be sworn in. Do you solemnly swear that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Lopez, you may proceed. I don't know if your client would like to have to make a narrative statement, or if you'd like to do a question-answer format, but whatever's most comfortable for her.
I think the most efficient use of our time would be a Q&A format that will help us work through the facts as quickly as possible. So if you would state your name and spell it for the record.
Julie Ford, F-O-R-D.
And your former married name was Julie O'Rear, correct?
Yes.
And if you would please state the date of your birth.
March 8th, 1968.
And Ms. Ford, what is your highest level of education?
I have some college, community college.
And approximately when did you meet Mr. O'Rear?
1986.
And you two were later married?
Yes.
And what was the date of your marriage?
June 27th, 1987.
And you were married approximately 22 years?
Yes.
And how many children do you have with Doug?
3.
And at some point the marriage came to an end, is that correct?
Yes.
And you separated on December 14th, 2009?
Yes.
Does that sound about right? And your divorce was finalized pursuant to a written divorce agreement on February 7th, 2011, is that correct?
Yes.
And that divorce judgment was later entered with the court as a court judgment, correct?
Yes.
Now, during the time in question, the 2007 and 2008 tax years, what was your occupation?
I was a homemaker.
Okay. And prior to that, what was your profession or employment?
Up until 2000, I was a secretary, but hadn't worked out of the home since 2000.
Okay. And in addition to your duties as homemaker, you homeschooled your 3 children?
Yes.
Okay. Now, speaking about your relationship with Douglas, was he ever physically abusive with you?
Yes.
Okay. Can you just briefly explain for the panel what happened in that encounter?
We were arguing, and I was trying to leave the home, and he physically restrained me and pulled me back into the home and threw me against a wall and slammed and closed the door.
And how tall was Douglas?
Approximately 6 feet tall.
So he was big and intimidating.
Yes.
Was he ever verbally or emotionally abusive with you?
Yes.
Would you say that continued pretty consistently throughout your marriage?
Yes.
Okay. Now, what kinds of things would he do that make you say that he was emotionally and verbally abusive with you?
Well, he was he used his intelligence, I guess. He would always say he was the smartest person in the room. He was a financial genius. He would say that I couldn't understand the level at which his mind operated. I had a uterus for a reason. I was to bear children and care for children. Just manipulations as to my intelligence and role as a woman.
So his conversations with you were largely demeaning and insulting as far as your inability to comprehend his business or the family financial matters.
Yes.
Okay. Did you feel like you had a voice in the family as it pertained to business and finances?
No.
And he told you specifically that your home was that your place was in the home raising children, correct?
Regularly, yes.
So he didn't even allow you to participate in business or financial decisions?
Never.
And he didn't treat you as an equal as far as you could determine?
No.
Okay.
No.
Now, what specifically, if anything, did he ever tell you about family finances and where the household income came from?
He didn't tell me any specifics. He would tell me when to pay bills, what checks to write, when to write them. He just told me that he was a financial genius and was always working on big deals.
So you would pay household expenses like utilities and rent and the car insurance and various items like that, correct?
Yes, when he instructed me to. Yes.
Okay. But you weren't involved in his day-to-day business affairs?
No.
Okay. And he never explained to you what he did for a living or really discuss it with you?
No, he said I wouldn't understand.
Okay. And when I say that I'm thinking either, casual dinner talk conversation, this is what happened today, or even long-term serious discussions where you sit down and have a long, involved discussion about finances and where things are going. Neither of those, is that correct?
Never.
Okay. So you would say that he was pretty secretive, is that correct?
Yes.
Would you say he was paranoid?
Yes.
Would you say he was unreasonably secretive and paranoid?
Yes.
Okay. Did he have multiple cell phones?
Yes.
Okay. And did you communicate with him on only one of those cell phones?
Yes.
And to this day, you don't know what the other cell phone was for, is that correct?
No.
Okay. For your mailbox, did he lock your mailbox
Yes.
with a key?
Yes.
Did you have, were you provided a key to that mailbox?
I wasn't allowed a copy of
Okay. So you weren't even really able to get mail?
it. No.
Okay. So he would restrict your access to the mail, to your knowledge of what he did, to his day-to-day actions when he would leave the house. He wouldn't share that part of his life with you, really, it sounds like.
Correct.
And it sounds like he actually went beyond that to actively conceal what he did by restricting you from access to the mail, etc.
Yes.
Okay. Would you say that he was evasive and deceitful with you when it came to sharing information about the family finances?
There was no sharing. There was.
So in your mind, that would be deceitful.
Yes.
Okay. Did he also constrain your ability to join Facebook and social media sites?
Yes. I wasn't allowed.
Which, because you're from Australia, that would be even more important to you to keep in touch with family and friends back there, correct?
Yes.
Now, do you think all of these restrictions that he imposed on you, was this a result of his secrecy and paranoia and evasiveness?
Yes.
Okay. What would Doug restrict your ability to talk to your friends on the phone when he was there?
Yes. I wasn't allowed to use the phone when he was home.
Okay. And again, he never volunteered information to you about his business or finances?
No.
But did you ever ask him what he did?
I did.
Okay. How many times would you say?
Many, many times.
Okay. And again, can you tell us some of his typical responses to these inquiries?
Usually the first response is, I wouldn't understand what he did. But he had said from time, or at a time, that he bought and sold stocks.
Okay. All right. And to the best of your knowledge, was that with Mr. Gelsich?
I didn't know at the time, but I now understand this was with Adam Gelich.
Okay, with information you've discovered after
Post
divorce.
divorce.
Okay. Now, did Doug think he was smarter than everybody else?
He told myself and anyone who would listen that he was the smartest person you knew or the smartest person in the room.
Okay. And did he bragged about how smart he was?
Regularly.
Okay. Did he call himself a financial genius?
Regularly.
Okay. Now, did he feel that he was too big and sophisticated for small town rural Ventura County?
Yes.
Okay. So, so generally speaking, he thinks that he's above everybody else due to his superior intellect.
Yes.
Okay. Did he have a business office that you were aware of?
No.
Okay. So where did you understand he worked?
He took a lot of phone calls at home behind closed doors, and he traveled a lot.
Okay. So he traveled a lot, and would he leave town unexpectedly
Yes.
without announcement?
Yes.
How many times did he just leave out of town unexpectedly?
More times than I can count.
Would he do things like call you from the airport or a taxi cab?
Yes.
Okay. And that's when you would first find out that he was leaving for extended periods of time on business?
Yes.
Okay. Would he ever tell you anything about the nature of his travel, where he was going, why he was going?
Mostly it was a big deal, big business.
Okay. Those were his words?
Big yes.
So he would call you from other cities and states and countries, and tell you that he wouldn't be coming home?
Yes, it was a dire emergency for big business.
Okay, okay. Can you give me some examples of the places he would call you from?
It seemed like Las Vegas was a very regular spot. Australia, Korea, Germany, New York. Sometimes there was one or two, Boston, mostly Las Vegas.
So did you consider him an absentee parent?
Yes.
Okay. And obviously his traveling made it more difficult for you to ascertain what he did for a living.
Yes.
Now, Exhibit A that we've stipulated to be admitted is your state tax return for 2007, and Exhibit C is your state tax return for 2008. You've had a chance to review those exhibits, correct?
I've seen them, yes.
Okay. And do you recall signing either of these forms?
I don't have independent recollection of signing them, but that's not unusual, because I don't prepare them, but they would be handed to me to sign.
Okay, all right. So, did Douglas have a regular CPA or tax preparer?
No.
Okay. So he didn't have, for somebody who is always involved in big business deals and constantly traveling, he didn't have a CPA or a bookkeeper that he met with regularly throughout the year or throughout the course of your marriage?
No.
Okay. So, who would you say was responsible for preparing the taxes?
He was.
Okay. And what did you know about his efforts to prepare the tax returns? What did you know about that process?
I would see him use TurboTax from time to time, and then he would go down to H&R Block and tell them the numbers, and they would generate a tax return.
Okay. Were you invited to those meetings?
No,
Did you ever meet with the CPA during those meetings?
there wasn't a CPA to my knowledge.
Okay.
A tax preparer, perhaps.
And Doug would schedule and attend those meetings without your knowledge, is that correct?
Yes.
Okay. So he was the one that was responsible for providing information and documentation to the CPA, or to the tax preparer?
Yes.
Okay. And did you have any discussions with Douglas before he met with the accountant to talk about what was going to happen and about filing the tax returns?
No.
Do you have any idea to this day where he got the numbers or how he calculated the information that was provided to the tax preparer?
No.
Okay. Now, I'm going to reference Exhibit C, page 5 of that document, which is Schedule D. And it lists it's actually Exhibit D, page 5. And this, do you recognize this exhibit?
I don't know any of the entries.
Where any of this information came from?
I don't even know the names of these.
Okay. Do you recognize a company by the name of BioSolar?
No,
Do you know what that does?
I don't.
Were you involved in the decision to buy BioSolar stock or to sell BioSolar stock?
No.
What about Cerritos? Do you know anything about Cerritos or what that company does or why Douglas was buying and selling it?
I don't.
Okay. Is it fair to say that all of these entries on here represent transactions that you are not familiar with and were not involved in?
I don't know anything about them. I was not involved.
Okay. Did he ever approach you and say, I'm thinking about buying some stocks, what do you think?
No.
He never consulted with you or sought your input as to whether you thought it was a good idea or not?
No.
Okay. Do you think that Doug used TurboTax, and this is in hindsight, do you believe that Doug used TurboTax and H&R Block instead of a more regular or sophisticated tax preparer because they would probably ask fewer questions and maybe even rubber stamp the return?
Yes.
Okay. So that's your understanding. To this day, you don't have any access to any documents or records that would shed light on Doug's business dealings or how he prepared and populated the tax returns with those numbers?
No.
Okay. So in the course of paying your household expenses like utilities and car insurance and other formalities, did you also prepare in your memory checks to the IRS and to the FTB?
At his instruction, yes.
Okay. And so Doug would tell you how much to pay?
Yes.
Okay. But you nonetheless were you were preparing returns and you were writing checks out to the government. So in your mind, were you paying and reporting taxes as required by law?
Taxes were filed and taxes were written.
Okay. But you personally wrote checks to IRS and FTB?
Yes.
Okay. So regardless of whether Doug gave you the right information or the right numbers to pay, you still had a reasonable belief that you were complying with the tax laws. Is that correct?
Yes.
Okay. Did Doug ever give you access to any records or information that would allow you to independently verify the numbers that he was putting on the return?
No.
Okay. So you don't even know if those were accurate?
No.
Okay. Before you signed the tax returns, did Doug ever sit down with you and go over them?
No.
Did he ever give you a final draft of the returns before he asked you to sign them?
No.
Describe how much time Doug would typically give you before you had to sign one of these returns.
He would call me from H&R Block and say, come down here now, you need to sign this. And there was a time or two where he met me in the parking lot with H&R Block and handed me a document to sign through the car window and say, sign here.
And what did you think would happen if you said no, or you wanted to ask more questions?
He would tell me I wouldn't understand.
Okay. Were you intimidated about asking him for that kind of information?
Yes.
Given his history of physical and verbal abuse?
Yes.
Okay.
Excuse me, Mr. Wilder, sorry to interrupt.
Sure.
Can FTB have a brief recess to discuss the testimony that the appellant has given currently? I know it's unusual to.
You don't wanna wait to the end of it, you wanna?
If you like, I'm almost done with my
Okay.
examination.
Yeah. No, sure.
Maybe 3 to 5 minutes at most.
Okay.
And then we'll break.
Okay, sure.
Okay. So have you received any spousal support from Doug that he was required to pay in the divorce judgment?
In 2010, I received 3 monthly alimony checks.
But nothing since 2010?
Nothing.
And you had primary custody and all attendant obligations of your 3 children?
Yes.
All minor children, correct? They're now age of majority, but for most of this time period, they were minor children. Is that
My
correct?
eldest child was almost around 18, almost 18, the eldest.
Okay. Did you receive any child support from Doug under the divorce judgment?
No.
None. Has his failure to pay court-ordered support, has that put you at a disadvantage economically?
Yes.
Okay. Can you explain just very briefly how that disadvantaged you?
I've had to seek out sources of income for myself post-divorce, and had to learn how to be responsible for finances.
So in the divorce judgment, Doug specifically agreed that he was responsible for all of the consequences related to 2007 and 2008.
Yes.
That was your understanding?
Yes.
So he was accepting responsibility for those tax obligations.
Yes.
Has he made any effort to stand by those obligations?
No.
Have you spoken with Doug recently?
No.
When approximately was the last time you spoke with him?
Spoke approximately 2011.
Does he communicate with your children at all?
Not to my knowledge.
Do you know where Doug is currently?
I haven't known where he is since he left the home in 2009.
Okay. Have you had any business dealings with Doug after the divorce?
No.
Do you have any access to his business records or documents currently for 2007 or 2008?
No.
Have you ever had access to his business records or documents for 07 or 08?
No.
So you don't have any documentation in your possession, despite your efforts, to dispute the FTB's position regarding the value of the stocks that Doug purchased?
No.
And would that also be safe to say that you don't have any documentation that would allow you to go back and reconstruct or better understand what Doug was doing from a business standpoint?
No access.
So you're still in the dark as to really what he did?
Yes.
Okay. And he left you, as they say, high and dry, holding the bag.
Yes.
Real briefly about Mr. Gelsich. Who is Mr. Gelsich?
He is my financial advisor at Wells Fargo.
And when was the first time you spoke with him?
First time I spoke was approximately 2013.
Okay. And up until that time, he had been Douglas's broker,
I now understand that, yes.
based on your understanding now, okay. And up until that time, up until post-divorce, all communications, interactions with Mr. Gelsich regarding your financial and business matters were handled by Doug, is that correct?
Yes.
Okay. Prior to the finalization of your divorce, did you have any discussions with Mr. Gelsich regarding your and Douglas's financial or business matters?
No.
Okay. Assuming that Mr. Gelsich assisted Douglas in buying and selling stocks, would you ever be consulted or involved in those transactions, either by Doug or Adam?
No.
Okay. So you had no involvement or input into Mr. Gelsich's buying and selling stocks for Douglas?
No.
Okay. I think we would rest on direct examination.
Okay, then, you want a 15-minute break to,
Actually, FTB does not need a recess. We'd just like to revise our position in regards to the innocent spouse issue. Based on Mrs. Ford's testimony regarding physical, verbal, and emotional abuse by Mr. O'Rear, FTB will revise its position in regards to whether or not Mrs. Ford is eligible for the 1/2 attributable to herself. And therefore the same analysis in regards to equitable innocent spouse relief in regards to the balancing factors, those weigh in favor, and therefore FTB will grant her full innocent spouse relief. Or FTB's position is that it will grant full innocent spouse relief for the tax years at issue.
okay, well, based on that concession, then there's no remaining issue other than the initial appeal is whether an adjustment to basis is warranted.
Correct.
Okay, so on issue number 2, Franchise Tax Board is conceding that Ms. Ford is entitled to full innocent spouse relief. And so there's, unless you have more evidence, Mr. Lopez, on the issue of basis, I don't think there's anything left for us to do.
No evidence on that. We would submit to the FTB's proposal.
Okay, so if, do you have anything else that you want to say before I adjourn?
Not at this point.
Take it. And do you have anything else that you want to present?
Not to present, FTB would ask whether or not Mrs. Ford would still like to pursue the substantiation or whether she'd like to concede to the substantiation issue.
Our position is that we have no access to any documentation that would refute or, we believe the basis is somewhere above zero, but in observance of the taxpayer's burden to document and support basis claim, we don't have any evidence that would substantiate the basis, but our position is that Ms. Ford was unable to gain access to that information.
So since Mr. O'Rear has not, he filed the initial appeal but has not participated in quite some time, I think the only thing we can ask of Ms. Ford at this point is whether or not she wants the remainder of the appeal to be decided on the basis of the written record that exists today. Would that be acceptable?
I think that's appropriate, Your Honor.
Okay. So we'll do that. We will write up, we'll give you a written decision. We'll do it on the basis of the current written record on the, with respect to issue number 1, and with respect to issue number 2, we will write that FTB has conceded full innocent spouse relief.
I apologize, spoke too early. We would still like to be heard on issue 1 regarding the substantiation.
Okay, so you want to do a closing argument with respect to the substantiation. And you, Mr. Lopez, you've said everything that you need to say on that issue, right?
I believe so.
Okay. You may proceed then on that issue.
Good morning. The appellants have failed to substantiate their basis of capital assets in 2007 and 2008. The appellants have been given ample time, over 8 years, by respondent and the Board of Equalization, now the Office of Tax Appeals, to substantiate their basis, that failed to do so. Respondent's determination of basis is presumptively correct, and it's the appellant's burden to show that it's erroneous. Therefore, respondent's notice of actions increasing the taxpayer's gain for capital assets sold in 2007 and 2008 should be sustained. Thank you.
Okay. Do you have any response, Mr. Lopez?
No, Your Honor, other than we don't have any we don't have access to any documentation to either support or refute the FTB's position.
Okay. Are there any questions by Mr. Ewing?
I have none, Judge Stanley.
No questions.
Okay. Well, then we'll adjourn today's hearing and we'll issue a decision within 100 days, and we won't need to address the issue of Mr. Gelsig.
Right.
Correct?
That's correct, Your Honor.
Okay. So I won't set up a timeline for further witness declaration for that, getting that document. Okay, we're adjourned. Thank you.
Thank you.